الله الشيطان الرجيم بسم الله الرحمن الرحيم رب اشرح لي صدري ويسر لي أمري واحلل عقدة من لساني يفقه قولي. So today we shall be talking about the International Criminal Court, and this will be our last lesson for this course. So today we'll be finishing our course. Then tomorrow you will be doing a quiz, and the quiz will cover the first three chapters or the first three lessons. That is module 1, module 2, and module 3. So tomorrow you'll be doing the quiz. Then you will prepare for the final exam. Now, let us start our lesson. So the first thing today, these are our lesson's objectives. That is, by the end of this lesson, you should be able to, number one, define the International Criminal Court and explain its purpose in the international justice system. 2, describe the role and jurisdiction of the International Criminal Court, including the types of crimes it handles. Number 3, identify and explain the rights of the accused and the rights of victims under the International Criminal Court. Then outline the trial process and key procedural rules of the ICC. Then explain the role of victims and witnesses during the ICC proceedings. Then lastly, discuss the sentencing procedures and forms of reparation available to victims. Then we shall also talk about the challenges that are basically facing the International Criminal Court. Now, number one is the definition of the International Criminal Court. So what is the International Criminal Court? So the International Criminal Court is a permanent, independent international tribunal established by the Rome Statute in 1998, which entered into force on July 1st, 2002. So the International Criminal Court, it started operating and dealing with cases formally in 2002. So any case from 2002, any war crime or any crime of aggression or any genocide that happened after 2002, the court can deal with it. But anything that happened that is from before 2002, the court has no jurisdiction. The court cannot actually deal with those cases. And the headquarters is in Hague, that is Netherlands, and it is not part of the United Nations. So the ICC, it's not part of the United Nations, but has a cooperation agreement with it. So sometimes the United Nations can forward a file to the International Criminal Court. So the International Criminal Court can analyze and review. So that is the only agreement and relationship they have. So its primary mandate is to prosecute individuals, not states, for the most serious crimes of international concern. So the International Criminal Court deals with individuals. It doesn't deal with countries. And it deals with those four cases those four types of crimes under the international law, the international criminal law. That is the genocide. We have the crime of aggression. We have the crime of humanitarian, and so on and so forth. Now, what is the purpose of the international justice system? Or what is the purpose of the International Criminal Court? Why is it important? That is, so number one, ending impunity. So it basically holds perpetrators accountable for grave crimes that shock the conscience of humanity, deterring future atrocities. So they are there to end impunity, meaning that those people who are involved in those crimes, they are brought to book. They need to be accountable, because if you don't do that, they'll continue killing people, engaging themselves in those atrocities. So we need to put an end. Then complementarity, like we said in our last lesson, the ICC acts as a court of last resort, complementing national judicial system. So the court only comes as a last resort. It only intervenes when in Somali, the courts in Somali, for example, fails to deal with cases or does not have the capacity. That is the only time the International Criminal Court can come or can help. Number three, victim centered justice. So, unlike earlier tribunals, the ICC incorporates victim participation and reparation into its procedure. So, the ICC is inclusive in its approach. So the victims also they normally have a chance. So they normally have a chance. They can be heard. They can come to ICC. They can act like witnesses, and also they can be compensated at the end of the day. So victim-centered justice, their justice is focusing more with giving rights to those who are affected by those atrocities. Then promoting promoting rule of law. So it strengthens international legal norms and encourages domestic legal reform. So promoting rule of law basically means when people do anything or people do something that is not good, they are subjected to the law. So it strengthens international legal reforms, and also at the same time it encourages domestic legal reforms. Sometimes the ICC, it normally visits especially countries in the developing countries, and it helps them to build to strengthen their courts, delivering justice for victims. So it provides a platform for victims to be heard and seek reparation. Reparation means it's a sort of compensation, contributing to reconciliation and peace. Now, what are the roles of the ICC? The roles include number one, of course, it is a judicial body. So it adjudicates cases against individuals accused of international crime. So, what is the meaning of adjudicate? Adjudicate basically means the ICC, they normally listen to all the cases, the witnesses, they provide the witnesses, the defenses. So it is basically the trial process. Adjudication is all about the trial process, where the accused is there, plus the defense is there, the victims is there, giving of the evidence, listening to both parties. That is the process of adjudication before making the ruling. Then preventive mechanism deters potential perpetrators through the prospect of prosecution. So deterring means preventing future occurrence of the atrocities, the genocides, and so on and so forth. So if people know that they're going to be subjected to law, they're going to be accountable for their decisions that they made, then it will deter future atrocities. Catalyst for national action. So it encourages states to strengthen their own judicial capacity to avoid ICC intervention. So the fact that the ICC is there as the last resort, it also actually push and promotes and encourages the national courts to strengthen their system, because we don't want every time to be going to the ICC because our systems are weak. Now, what are the jurisdiction of the ICC? So the ICC's jurisdiction is based on the following principles. Number one, complementarity. That is, it only steps in if national courts fail. So, for example, if the courts in Somali fail, or sometimes if the courts are not fair, if the courts, for example, are corrupted, so people can decide to raise their file to the International Court of Justice. Number two, territorial and personal jurisdiction. Crimes must be committed on the territory of a state party. So, for example, if Kenya is a state party and the crimes happen in Kenya, so the International Criminal Court can intervene. But if a member is not, for example, if a state is not a member of the ICC, then the ICC court has no jurisdiction, basically. You know? So crimes must be committed on the territory of a state party, because not all the countries are members of the ICC court. Some countries are not members of or have not subscribed to. Or, so that is the first option, or by a national of a state party. You know? So crimes must be committed on the territory of a state party, or number two, by a national of a state party. For example, if I'm a Kenyan and I go to another country, and I do what? I do the atrocities in another country, I can be taken to a court of law as a Kenyan, because Kenya is a member of the ICC court. Okay? So what about the non-state parties? Non-state parties can accept jurisdiction ad hoc, or the United Nations Security Council can refer situations. So non-member states, they're not obliged to force, but they can just accept jurisdiction ad hoc. Ad hoc means that the ad hoc basically means they هناك الخيار, voluntarily, nobody can force them to do what? To accept it. خيارا يعني. And sometimes the United Security Council can refer situation to the ICC, whatever, ICC court, like the case of Darfur and Libya. It is the UN Security Council that forwarded the files to the ICC to follow up and bring justice. Then temporal jurisdiction, time, the scope. Only crimes committed after July 1st, 2002 are covered. So any crime that happened before that cannot be taken to that court. Now, the next part is about the types of crimes. This one will not talk about it, because in our last lesson we talked in detail about the crime. So the ICC, they deal with these cases: genocide, crimes against humanity, war crimes, crimes of aggression. So these are the cases that they deal. They don't deal with any other cases. They normally focus with these four types of crimes. Now, what are the rights of accused based on the fair trial standard of the Rome Statute, Article 55 and 67? So the accused, they have their right. Just like it happens in a normal court, the accused, they have their right. It does not mean that when you are accused, then you have to be suppressed. No. So number one, there is the presumption of innocence until proven guilty beyond doubt. So yes, you can be arrested, but we assume that you are innocent unless there is evidence, that shows like 100%, you are liable. Then number two, right to be informed of charges in a language the accused fully understand. So if they take you to the International Criminal Court, they need to inform you of what did you do in a language that you understand. Then right to legal assistance. You have the right to find a lawyer, including free legal aid if unable to afford counsel. So sometimes the ICC, they have the option of providing you with lawyers in case you will not be able to afford one, but you have that right. Then right to remain silent. So without such silence being considered an admission of guilty. So you have the right to remain silent, so long as that so long as that silence cannot be attributed or considered to be an admission of guilt. Sometimes you being quiet means, yes, it means that you accept, though you did not talk, you remain silent. It basically means you are liable. Then right to confront witnesses. You have the right to confront the witnesses through your lawyer and present evidence in one's defense. So those witnesses, your lawyer can ask them question, like it normally happens in any court. Protection against double jeopardy. Cannot be tried again for the same crime. You cannot be charged or you cannot be tried twice for the same crime in two courts. It can never happen. The only time that it can happen is when they provide new evidence. So when they provide some new evidence, then they can recharge you, they can retrial you because there is some new evidence. Or maybe if it is considered there were some procedural errors, the judges made some errors, the judges were not unfair. So those are, but in general, you are protected. Then right to an interpreter, you can have and translation of documents. It's very important. You need somebody, like we said in number 2, you have to be informed in a language that you can easily understand. All the documents will be translated in a language that you can easily understand. Then right to be present at trial, with exception for disruptive behavior. You have the right to appear in court, unless if they consider you are going to be aggressive or you are going to be disruptive. That is the only time you will be denied this right. So these are the common rights of the accused in the International Criminal Court. Now, no, so these are the rights of the accused. Now we have the rights of victims. These are the rights of the victims who are affected by the war crimes, So what are their rights? Number 1, participation. They have the right to participate. Victims can present their views and concerns at appropriate stages of proceedings. So they have the right to participate, to give evidence, protection, measures to ensure safety, dignity, and privacy. That is anonymity. That is why in ICC, sometimes you'll find that, for example, in Kenya, we had the case of Ruto. I think it was some years back. There was a case that he was taken to the ICC. There was the case, I think it was in 2002, of the post-election violence. So the case was, and there were some witnesses. So those witnesses, they were protected. So they were using letters. Witness X said this, witness Y, witness B, witness C. So it is for the protection of the victims. Reparation, this is very important. Right to seek compensation. Compensation means monetary. They have to compensate you. If, for example, your house was demolished, you have to be given money to build another house. That is the meaning of compensation. Then we have the restitution. Now, when we are talking of restitution is not monetary. Restitution is you have to be taken to a court of law, and if you are found guilty, they have to take you to a jail, to prison. This is the meaning of restitution. So restitution, like you have to go to a court of law, the court will decide. Then rehabilitation basically means, like, for example, those who are injured, they can be taken to hospital, and you can pay for their what? You can pay for their bills. So that is the meaning of rehabilitation. And symbolic reparation. Symbolic is not monetary. Symbolic is those people who are involved. What do? You just have to apologize. For example, they tell you, okay, now halas, we don't need money, but we need our dignity back. Just publicly, you have to acknowledge you did the mistake, and that you are asking for forgiveness in front of people. That is that is the meaning of symbolic reparation. Or sometimes there are memorials. For example, in Rwanda, as in every year there is a memory to remember that day. It's so about what happened. So it's a memorial. Then support access to legal representation through the Office of Public Counsel for Victims. So the victims can also get lawyers to defend and represent them. Then information, the right to be informed about proceedings and the progress of cases. So these are the rights of the victims. Now, on to the most important part, the trial process. The trial process and key procedural rules of the ICC. That is, for example, today, somebody you want to forward somebody to the ICC. So what are the stages, or what is going to be the trial processes? So we have around 7 processes. So number 1, you have the preliminary examination, investigation, arrest and surrender, pre-trial, first, the trial first, appeal, then the enforcement of the sentences. So this is the trial process. So number 1, the preliminary examination. That is the office of the prosecutor analyzes information to decide whether to open an investigation. So just like what South Africa did in the case of Gaza and Palestine, they presented there what they have, you know. So the office of the prosecutor will analyze this data and this information to decide whether to open. Should they open this file or they should not open? And there are some factors that they have to consider. Number 1, jurisdiction. Remember, we talked about the jurisdiction. We have the time jurisdiction. When did it happen? That is number 1. When did it happen? Number 2, how did it happen? How did it happen? Then number 3, who was involved? So it has to determine all those things. Then admissibility. What was the gravity? What was the gravity and the magnitude of the crime? Then the complementarity. The issue of this case was this case. Did the national court, for example, in Somalia, intervene before being forwarded to the ICC? And of course, interest of justice. So that is the preliminary examination. Number 2 is investigation. Now they open the file, they decide to go to the next step, investigation. So the office of the prosecutor collects evidence, interviews witnesses, and seek cooperation from the states. And the pre-trial chamber, the pre-trial chamber normally consists of 3 judges. The pre-trial chamber may issue orders to protect victims or preserve evidence. Then, after the investigation, then there's the arrest and surrender. So the ICC issues an arrest warrant to those people who have been involved or summons them to appear. So state parties are obligated to arrest and surrender suspects. So if you are a member of the ICC, then you are obligated. So for example, like Kenya is a member of the ICC. If Netanyahu goes to Kenya, Kenya is supposed to arrest Netanyahu. Why? Because Kenya is a member of the ICC, just like South Africa. So the member states, those if they are liable, they cannot visit actually. But it does not happen. Fil ardul waqi. It does not really happen. Most of the time, state parties are obligated to arrest and surrender suspect. No ICC police force. The ICC, one of the challenges, it does not have police force. It relies on state cooperation. So, for example, Kenya can just decide, like the issue of Bashir, the issue of the former president of Bashir, there was a case against him in the International Court of Justice, and there was an arrest warrant. So there is a time Bashir visited Kenya. So there was a pressure from Kenya. Oh, Kenya, you need to arrest Bashir. But in the end of the day, Kenya said, no, we cannot arrest Bashir. And it was not fair. So we can decide not to cooperate, and nobody nobody can ask you, why did you not arrest him? So you can just decide, no, we are not going to arrest him because we also have our interest. Then the pre-trial phase. Now, if you are arrested, they can bring you now to the next stage, the pre-trial. So you are informed of the charges. So the confirmation of charges hearing, the pre-trial chamber determines if there is sufficient evidence to proceed to trial. Charges may be confirmed, rejected, or amended. So at this pre-trial, three things can happen. Number one, it can be confirmed. Khalas, this one, the evidence is enough. We need to go to the next trial first. Or it can be rejected. The evidence, we do not have enough evidence, So they just decide to close the file. Or they can decide to amend the file. They can just ask for further information, further clarification. Then the trial phase. So it is conducted before a trial chamber of 3 judges. Both prosecution and defense present evidence, both of the parties, the prosecution and the defense, examining witnesses. Those witnesses, they are subjected to some question, and there are some arguments. Both sides, they present their arguments. Judges ensure a fair and expeditious trial. Expeditious means the trial is done what? It's done quickly. They don't drag. Sometimes you find that there are some cases, they normally take years before the final decision. Now, the next thing is the appeal. So they might decide that, Khalas, you are liable, but you can appeal. Either party may appeal verdicts, sentences, or reparation orders to the appeal chamber. So we have an appeal chamber of 5 judges. If you are not satisfied with the decision, then sometimes when you're appealing, there are many issues that you can raise in your appeal. Number one, you can say that there are some procedural errors. When you are talking about procedural errors, I need you during your free time, go and research more about the procedural errors. So when you're talking about procedural errors, maybe one of the things sometimes that normally have the time of submitting the files, because the courts, they normally tell you, okay, we need all the parties to submit their files by maybe the 10th of January. Maybe some parties, they submitted their files after 11th. So you can just say, no, there are some files that were presented after the deadline. So that is known as a procedural error. Then there is the error of fact or law, because sometimes the judges are human beings. Maybe sometimes they can make error about what is really the fact, or maybe they can misinterpret the law. So there is a chance you can appeal and they can review that. And sometimes unfairness, where you think maybe one of the judges, you are not satisfied with one of the judges. You just think that the judges, maybe one of the judges was corrupt, one of the judges was biased, so you can just appeal. So these are the grounds for appeal. Then lastly, enforcement of sentences. So normally it's a maximum. Sentences are maximum 30 years, or sometimes there is life imprisonment, are served in states that have agreed to enforce them. So this imprisonment normally happen in the states, members of the states. Either, for example, in our case, it can be in Kenya, or if it is not in Kenya, another member of the ICC, we can decide that the case is going to be there. Now, we only have 10 minutes remaining. So we have the role of victims and witnesses. Like we said, the victims, they participate, they can submit evidence and observation, they can seek reparation. And we have seen the types of reparation. They have to be informed of the proceedings. Then the witnesses, they have to provide testimony. To provide testimony crucial to establishing facts may include victims, experts, or insiders. So the witnesses. So the witnesses can be the victim themselves, or it can be experts in law, or it can be insiders themselves inside the ICC. Receive protections from the victims, and so all the witnesses, they have the right to be protected. Now we also have the sentencing procedures, you know. So after a guilty verdict, a sentencing hearing is held with both parties. We've already talked about this. The forms of reparation, this is what I was talking to you. The forms of reparation. The restitution, restoring victims to their original situation, compensation, monetary award. So because of time, the key challenges, quickly, the key challenges of the ICC. Number one, there is the limited jurisdiction and membership, you know. So the ICC only has jurisdiction over states that have ratified and the Rome Statute, or crimes referred by the UN Security Council. Non-state parties that voluntarily accept ICC jurisdiction. Major world powers such as the United States, China, Russia, and India are not parties. Like now, look at the issue of the ICC, the issue of Netanyahu, Mathalan. America is just saying, oh, the ICC is not a court, they don't recognize it. So they lack the jurisdiction and the membership. You know, not all the members in the world are part of it. So they lack the universal jurisdiction. Number two, dependence on state cooperation. So they don't have their own police. They rely, if they want to arrest somebody, they have to rely on the country, you know. So because they don't have their own resources, sometimes it becomes very difficult to deal with cases, you know. Number three, political influence and selective justice. Many, only the ICC, they normally say it only deals with cases from Africa, like the issue of the Taylor, Bashir, and what. They only deal with our cases, but cases that are from the developed country, you cannot hear the ICC dealing with cases from UK, Netherlands themselves, Germany. They don't deal with cases from those countries. So selective justice. Then political influence. They're influenced by the G8s or the G20s. Perceived bias against African states. So they are only focused with Africa. So it is a form of neo-colonialism, you know. They normally threaten African leaders, arrest them, ila ghairi dhalik. So there is perceived bias, then slow and costly judicial process. So if you take a case now, look like the case of Palestine, you know, it is still there, it's still continuing. So sometimes these cases, they take a lot of time. And for example, you have your lawyer, you have to pay the lawyer, you have to travel to go there. So sometimes it can be very difficult. Challenges in evidence collection. Sometimes collecting the evidence becomes very difficult, especially the countries where people are fighting. Getting evidence sometimes become very difficult, or sometimes they destroy the evidence. Then enforcement of arrest warrant. So the ICC, they issue the warrant, but they depend on states to execute them. So ICC cannot arrest. They will just sit and wait for the member states to arrest, you know. So sometimes some members who have been accused, they just walk around, they don't even fear anything. Limited deterrent effect. So one goal of the ICC is to deter future crimes. But according to what is happening in the world, no deterrence has happened. In fact, the opposite is happening. There are a lot of wars happening in the world. Like recently, even America, they decided to attack Venezuela. That is a crime of aggression. Remember in our last lesson, because Venezuela is a sovereign state, but America, they decided to attack their sovereignty. And they're just keeping quiet. So if America is doing it, Russia is doing it, it's okay. But if Somali, Kenya is doing it, there is a problem. This is what is known as selective justice. You know, so it is just there. Those courts, they're just there, but they're not doing basically anything. So tension with national sovereignty. Sometimes there is a tension between ICC and member states. Resource and capacity constraints. Sometimes they lack the capacity. So you have the solution. So for every challenge, you have a solution and how it can be solved. And you have the links. You can follow this link and you'll get more information about ICC and what has been happening with ICC. So this was our last lesson for this course. So tomorrow you'll be doing a quiz. So tomorrow you'll not have a lesson. Tomorrow you'll do a quiz, and the quiz will cover the first three lessons: lesson 1, lesson 2, and lesson 3. Then the final exam will be lesson 4, 5, 6, and 7. So the final exam will be the last 4 lessons. Then the quiz will cover the first 3 lessons. So tomorrow you'll have a quiz. You'll be having like 40 questions. Each question will be 1 mark. Then the 40 will divide the 40 by 2. So the quiz is 20%. The final exam will be 60%. Then the attendance is 20%. So that is the end of this course. Hopefully, maybe we'll meet in another course, inshallah. So if you have any question before we leave, you can ask. If you have any question, if you need any clarification, you can ask. We still have some 2 minutes. Is there any question? Yes, please. So I'm sending the attendance in your groups. So you can take the attendance now before we disable the link. Just take the attendance. I've sent it in your groups. So if there is no question, inshallah, let us meet tomorrow when you'll be doing your quiz. Then the management will inform you when you will be having your final exam. But I think you'll have your final exam next week, no problem. Maybe, I'm not sure about it. Okay. So I think that is the end of our course. So let us meet tomorrow, inshallah. Ma'as salam.